Hey everyone, thanks for being here today. Today we're going to hear from Magistrate Brenda Lindsay-McDaniel. She's in the Child Support Court for Fourth Circuit and Chancery. She was appointed to the bench in 2002. We also have Judge Patricia Hall Long from General Sessions Court. She's been on the bench since 2008. And we have Judge Kyle Hixson. He's on the bench in Criminal Court of Knox County, Division 2. He has been there since the beginning of 2020. We're gonna let them share any tips that they think that new lawyers in Knox County should know. It's an informal discussion and we'll have a time at the end for questions. I wanted to make sure that you guys were aware that there's a KBA Expo on April 7th, 8th, and 9th. And there's also a KBA social hour Thursday, April 22nd. So put those on your calendars and be on the lookout for emails from us about a new lawyers section networking or social event towards the end of April. We're planning on that being at the Beard and Beer Market. So stay tuned for that. Now I'm going to turn it over. Magistrate, would you like to go ahead and start?
Sure. I'd be happy to. I'm always happy to talk to the new lawyers and see the new people coming in. It's always fun to get some fresh people coming in with new perspectives and some excitement coming in. One of the things I would say, if you're new to the bar or you're just new and you want to come in and practice child support, come in. You're welcome to come in. The courtroom is open as much as COVID restrictions will let it be. We have plenty of room in here that you can keep your social distance, wear your mask, and so on, and observe what's going on in the cases now that we're back open, effective today. So you can watch what's happening and kind of get some experience. I know for myself, I've been doing this now 36 years, and it was helpful to me as a beginning practitioner to come into a courtroom and just observe what was happening. It would put me at ease. It would let me know what the procedure was, give me some indication of whether it was very formal or a little more relaxed. And then I felt more at ease myself in presenting my case. So feel free to come in, sit back and watch. And at the end of it, if you decide you want to go on my appointment list, just let me know. So you can tell my secretary, who is Brittany, let her know, give her your address and give her your phone number, and we will put you on the list and start just basically throw you into the fire and let you start handling some cases. So I found that that's a really effective way to start getting out there and learn these cases. You learn basically through just getting out there doing it. So you can tentatively sit back and wait and try and learn it that way by reading and so on. But I find you really learn a lot more if you just jump right in. So I will say this, if you're going to give your address and so on to the court to start appointing you to cases, if you don't have an office address, get a P.O. box. Do not use your home address as your address to give out to clients. Also with your phone number, a lot of you are going to, to save money and so on, you might think, well, I'll just let them have my cell phone. It'll be fine. I'll answer all my calls. Don't do that. Get a second phone number and use one for your work and then one for your personal life. You'll be very glad you did that. Give the private number that you have to my secretary. We will use that only if we need to get in contact with you. We won't give that to clients. We won't give that to anybody else. But if we ever see that you don't show up for one of your cases, we will use your private cell phone and try and call you and say, hey, you have a case on, where are you, to try and get you down here. So that can help to keep you out of hot water if you end up messing up. So the next point would be when you're in private practice or if you're on the appointment list, get a calendar, whatever calendar you use, whether it is just a little book or if it's one of the high-tech versions. Get a calendar that works, that you won't lose. Deal with any conflicts that come up. If you have several cases set in one county or a different county, something comes up, deal with it quickly. As soon as you see that there's a conflict that's going to develop, immediately take it on to try and resolve that conflict so that you don't end up at the very last minute inconveniencing the court and other counsel. You will definitely get a reputation, either a good one or a bad one, depending on how you handle crises that develop. And also, when you're dealing with your calendar, build in your vacation time. When you first start out of law school, you think, I don't need vacation time. I can work all the time. I'll just take whatever comes in. Build in your vacation time. The courts have a rhythm, and I think all the judges will tell you there's a rhythm. There's a time when everybody's in court and trying to get everything accomplished, and then there are the ebb and flow, the down times, when the clerks are trying to take vacation and to be out just a little bit. Those are the times that would be a good time for you to take some downtime, some vacation time for yourself, even if it's just an afternoon. And that way you won't have to worry about having conflicts with your court calendar as well. That can be helpful. Keep in touch with your clients. That's important when you're dealing with either your appointed clients or your private clients. Keep their telephone numbers. They change like the wind. Keep a list of all the numbers they've ever given you. Sometimes those numbers come in handy to hunt them down when you need to find them. Get an email. We found that out with COVID. It's helpful to have other ways to communicate with them. Text them. Most people these days don't want to hear from their attorneys, especially if you have bad news or if they don't like what you're going to tell them. Text them. Be ready to print out what you text them so that you can cover your file. Get a file, make a file on every client, document your file, and keep up with those things. You have to make sure that you are able to justify not only to yourself what you tell your clients, you need to make sure your client remembers what you told them, and you need to be able to justify it. In the off chance they file a complaint with the board, and those do occasionally happen, that you can justify what you told them that you would do or wouldn't do. So cover yourself. Always try and talk to your client the day before, at least the day before trial, to remind them they have court, remind them what their responsibilities are, when they need to be there, how they need to dress, how they need to approach the court, to be respectful, to not be on their phones. You know, there are so many different little things that just come naturally to you that will not come naturally to them. So try and put yourself in their place and just realize there are some things that they just need to be reminded of. And of course, if you have problems that come up, and you will, that you just aren't sure how to handle them, there are ways, there are resources to find out the answers. So don't just always try and look for them yourself. Don't just sit and panic about them. For the child support, you can always talk to the state's attorney if you have a problem with not understanding exactly what the file is, or if there's a question about an arrearage, or whether something has been credited to your client's account. You can ask the state's attorney to look into it a little bit for you or with you. You can look at the court file, which we don't keep the court files here. We get a lot of requests to look at the court file. We're a very small office. We don't keep the files here. They're in the clerk's offices. So you have to know which place. It'll either be Chancery Court, or it'll be Fourth Circuit Court, or it'll be in Juvenile Court, which is a whole different location over on Division Street. So you have to know where your court is. And then you can also, if you get to the point where you've got a real problem that you don't know how to handle, my door is open and you can come in and talk to me, not about the specifics of an individual case, but if you have a personal problem that is affecting your practice and you need to talk to me, you can come in and meet with me. The other thing I would say, enjoy the practice. It's great. There is nothing that I would rather have done with my life than exactly what I've done. So enjoy it. It's wonderful. And the last thing would be, of course, file your fee claims. I can't tell you how many times people have done the case, they've done all the work and have not filed the fee claims. Make the money. I mean, the money is there. It needs to be gotten. You need to fill out the forms, get it filed and make the money. Okay. Mary, I'll turn it back over and let somebody else have a chance.
I'm going to jump in real quick. We meant to say at the beginning, but if you have questions, so at the end of this, we're going to do a Q&A with each judge. And if you have questions and you don't want to put them in the all chat, you can DM them to me, and I will ask the judges at the end during our Q&A. If you have specific questions, just let me know which judge you'd like to answer.
Thank you, Campbell. Thank you, Magistrate. Judge Long, would you like to go next? Okay. Yeah, you're muted.
Okay, I'm doing something that my kids laugh so hard at. I was just touching my computer screen because I'm used to my phone. I am Judge Long. I'm in Sessions Court. I'm going to assume that who I'm talking to has very, very little knowledge about what we do. So some of this is going to sound very rudimentary, but you know, if you've never practiced there, I'm going to give you some of the just the logistics of it and then some tips. And I've done this seminar before, so I'm going to be looking down a little bit and reading from this. First of all, Sessions Court is the court where all cases start. I always say whether it's spitting on the sidewalk or murder, if it's in the criminal division, it's got to start in Sessions Court unless it goes through like a presentment, which is typically a sex assault or a child sex abuse type of case. And on our courts, we've got 5 judges and we rotate through the courts, which was an ingenious system put together a long time ago, which helps us from functioning, helps us to be able to not get sick of each other in certain DAs and certain courtrooms and certain types of cases. And it gives us new things to look forward to every week. But if you don't know what the setup is First Sessions Courtroom is the misdemeanor court. Second Sessions Courtroom is the DUI courtroom. Third Sessions is felony, and fourth is bonded arraignment. And the cited docket, which is all traffic citations in the city, in the county. The city citations, if you've gotten a traffic ticket, you know, is up at the police department. And then Fifth Sessions is civil division. That's the only time we're in civil division. And we rotate in that order through the courts: misdemeanor, DUI, felony, bonded arraignment, civil. And Donna and Esther, who are our secretaries, always have the court schedule and can keep you informed on that. Our dockets during COVID are all starting at 8:30. And so we want you to be there on time and ready to go. And especially if you have a jail case that's coming from us remotely from the detention facility, we really need you to be on time, because the way the IT works, criminal court is waiting for us to finish and they cannot start until we do our KCJ cases. So if you get appointed to a jail case and they're in the Knox County Jail, you have got to be on time and ready to go. We try to finish those within 30 minutes. You'll learn like DUI arraignments, domestic assault arraignments all begin at 10 o'clock, and that's when you would appear for those cases. But the earlier the better during COVID, because of the court limitations and size. Our dockets are rolling through pretty fast. And one of the things I would recommend is, if you practice out of county right now in particular, try not to double book yourself on certain court dates. We all need you in our courtrooms on time, and just really, really try to avoid that. But if for any reason you are overbooked, please let the DA involved know, or let my court officer or any of the judges' court officers know. And you should get all their phone numbers, because we do a lot of texting now. And I let them know I'm going to be in Sevier County and I should be there at 10 o'clock, whatever. That will help. I'm doing some stream of consciousness that I've done before on these pointers. One is, if you're in the civil, if you're in the criminal sessions division, you need to become very familiar with GIMS. That's the Justice Information Management System. And you can work with IT to get access to that on your cell phone and your personal computer, and you need to understand what it means. And it'll give you notifications, it'll show you your court schedule, and tell you a lot of information about your defendant, even their phone numbers and updated addresses and court dates and whether or not they might have outstanding process, which is one of the really important things you need to be aware of. One of the next things I was putting is make sure with the ADA, the assistant district attorney, if your client has outstanding process. Unfortunately, sometimes the ADAs don't look at that, and the clerk is the one who knows that, but you should be able to know that before court as well, because it's always very awkward when we pull somebody up to take care of an announcement on a case and we have to say, well, you know, we're taking them into custody because they've got a hold out of Sevier County, they've got a child support hold, they've got a federal detainer, they've got a criminal court violation of probation. Those are things you should know and be able to advise your client of, but definitely never take your client out of the courtroom to do that. We all need to cooperate in that instance. And if you get a reputation for somebody whose clients leave, that does not go well for you or your client. So on occasion that will happen, very rarely, but where somebody will abscond and just leave. But you know, if we have you approach and we tell you, now I'm sure you're aware your client's got outstanding process, you know, we want you to line up and, you know, you'll judge how to deal with your client, but they need to know, and they need to know what's coming and that you're doing whatever you can to help them out. I put always talk to your clients before you leave the courtroom. That seems obvious, but many times we'll have people that have multiple courtrooms they need to be in. They'll run through very quickly. They'll say there's a reset on Mr. John Doe for so-and-so date, and they'll leave. And then that client is sitting in the courtroom literally for hours, and we'll get them up later and we'll realize, you know, the case has been reset. And especially if it's reset now, like 2 months, they're really frustrated. That hurts your credibility with your client. And just try to avoid that. Either talk to them personally, text them, whatever, but they should know why your case is being reset, how far and for what reasons, and their future court date. Let your client know if you will be late. Looking at the anxiety on their faces as they sit in the courtroom while they're waiting for you to appear, it's very evident that this is not something that, you know, they want to be involved in, sitting in court. And if you'll just let them know, look, I'm in multiple courtrooms every morning, or I'm coming from Blount County, I'm going to be a little late, that really eases their concerns and just helps when we call out the docket and we're like, have you talked to your attorney today? And when they say, no, I didn't see my attorney since last time, I had one phone call from him, you know, that doesn't look good. And I ask them a lot of times. So I kind of know what the representation's like. If you decide to take appointed cases, you need to go to see Donna Corbett, our assistant. She will do a little background check to verify that your license is in good standing and add you to the list. If you get added to the list, you need to be prepared and ready to go from day one, because you're going to get appointments, and there is a notification that goes to you by email. And especially if you get appointed by the commissioner on cases that are in custody, they will have a hearing within 10 to 14 days, and you need to know immediately so you can, 1, check for conflicts, and 2, get out to the jail to be prepared and ready to go. If they come to court for their hearing and the witnesses are there and you have never met with them, that doesn't look good. So if you know you are going to take appointments, you have to have a lot of flexibility in your schedule, and you need to be aware that you've got to deal with things with urgency. If you know you're not going to have a hearing, you know, communicate. The communication's key between the DA and the defense attorneys in every respect. If you all are in open communication and working together, you know, there shouldn't be any surprises, and you can tell them this is a serious case. I can't be prepared by this day. Don't call in your witnesses, and let's pick a reset date. We are presently, a lot of these things I'm talking about change a little bit with COVID. We're presently trying to minimize appearances in court, even though we are having personal appearances. The Supreme Court order still asks us to minimize those. And there's a whole process through Esther, our assistant. It should be on the KBA website. It should be on the Sessions Court website, which describes how to get on Teams meetings and appear remotely. You can appear remotely with your client. You can even do guilty pleas remotely with your client, and you should try to utilize that. Check your appointment box daily if you take appointments. I say have the client wait inside the courtroom for the call of the docket. If you have a bonded client who will be present, make sure they're in the courtroom. We've issued attachments before where we think someone hasn't appeared and they're actually there, and the attorneys told them the reset and forgot to tell us. So always have your client appear in the courtroom. I don't like private counsel who say, try to minimize the embarrassment. part of being charged with a criminal offense is the embarrassment, and that's part of the deterrent involved. And I think every defendant should be sitting in the courtroom when I go over rights. And I don't want to have to repeat those, so make sure they're there at 8:30 if scheduled to be there. If you bring in a case that has an attachment, which is a warrant that issues for a failure to appear, and you've talked to the DA and you've been like, oh, my client couldn't be here Friday, his car broke down. Today, we're going to enter a guilty plea to simple possession. Always make sure that the clerk and the judge know that first, set the attachment aside, because they could enter a plea. We may not have taken the steps to set aside the attachment, or you've agreed to a reset, we forgot to set aside the attachment, and then they've got this warrant out for their arrest. You don't want that to happen. So always, if the case is not on the docket, look and see if there's outstanding process. Let's see, I was just made some notes to the side. Make sure that we've got a text number for you. We text a lot, and I start with my court officer in the morning, and I'm like, General Teeters, have you seen so-and-so, so-and-so? And we start texting and saying, do you know you've got a case on the docket? Because our nature of our cases is a lot of people get arrested the day before. There's no way you would know they're on the docket, but they are on the docket. It's fine that you can't be there that day. I just want to confirm with you that when I pick a reset date, it works with your calendar. So, if you're in the courtroom, we're going to have you run by if you can. No problem if you can't. But if I have your text, I'll ask Larry Pickard, my court officer, to text you and say, look, if I move this to Thursday, do you think you can be here that day? And that's really important. So make sure we've got your texts. Be realistic about what your capabilities are on appointments. When you get appointed now to a sessions court case, that is presuming that you will represent them in the plea agreement or the preliminary hearing, that you will follow the case to the criminal court for a potential jury trial, and that you will have the capability to file an appeal at the conclusion of that jury trial. You don't get to just decide, I only want to do sessions court work. It does not work that way. Either you are capable of handling the case all the way through, or you're not. And if I give you an appointment and I'm not familiar with you, don't take it personally if I have you approach the bench and I ask you what your experience is, because I'll have Class A felonies ready to go, stacks of those, because drug cases many times have conflicts. And be realistic. If you want to say, look, I want to start with misdemeanors, which is really where the money is, in my opinion. But if you want to do that, let me know, and don't go in the felony courtroom, and you won't get those appointments typically. Also, if you really want to build a practice and you want to do it through appointment work, you need to be in the courtroom. I almost only appoint people who are in the courtroom because I can verify the calendar. So hang out in the misdemeanor courtroom, approach us and say, I'm taking new appointments. I would love to get some work today. We will work with you. DUI is not a good case for appointment work. You do not have many conflicts in DUI cases. And that's just not the best courtroom to hang out in. Hang out in either misdemeanor or felony, whatever your capabilities are, and you will get work. And if you're there every day, it'll pile up before you know it. And like they said, be sure you coordinate your calendar and take some time off. Civil stuff, most people are in firms, bigger firms that do these civil cases, and you have a lot of guidance with mentoring in your offices. But if you've got any particular questions right now, we're doing that in the main assembly room. We do Monday through Wednesday in trials, Tuesdays detainer day, Thursdays and Fridays we do special settings, and you coordinate those through the judges if you've got a longer trial. Also, certain things, just personal pet peeves. I have attorneys who I feel like I'm the defense attorney sometimes, or the prosecutor sometimes. I don't want to be either. I just want to be the judge. And so like things like bail, if you've got under the COVID order now, we are very restricted in what you can hold somebody in on bond. We should always be reviewing that. I don't think that's my place at all. If somebody has representation, I assume if you've got a question about bail, you'll let us know, do your job and, bring that up. It's not the court's responsibility. It's also, I'll close like Brenda did and just say that I think Knox County has a great criminal defense bar and civil sessions bar. I think that there are always people who are willing to help you. If you find a good mentor, and pick multiple people, and don't ever hesitate to approach the judge. And don't wing it. If you've got a question or you feel like this is something you can't do, just let us know. Or we'll say, hey, go talk to Mr. Hedrick, or the type of people who are in court a lot, who have been there a long time. They will all help you. And I think Knox County has a great bar. And I think if you're going to get in trouble, unfortunately, Knox County is a place to do it, because we are so busy that you get good resolution. So if you start taking appointments, they're going to be impressed with your representation. It's going to help you build a practice. If you make sure you don't, unless you want to live that way, don't overburden yourself with appointments. And anything I can help you with, or you want to personally call me, feel free to. If you talk to Donna, she'll give you my cell number. I'm absolutely fine with that. And have a good time. Enjoy yourselves.
Thank you, Judge. Judge Hixson, can you take it now?
Yes, ma'am.
Thank you.
Mary, thank you for inviting me to do this. Thanks to you and Campbell and Jonathan for putting this on. I think it's a terrific thing that you're doing here, and I'm happy to take part in it. I will say, new lawyers, you really picked a fine time to enter the practice of law. Kind of like, I guess I picked a fine time to become judge. I became judge January 1st of 2020. And then about 2 months later, we broke this thing. Everything just completely fell apart due to the pandemic. And it's been a real strain on our system. But I will say, the people within our system, I'm really proud of how we've all come together to work through this thing. Hopefully we're getting on the tail end of it, but it has been a challenge. And it's something that we will be living with for some time now, unfortunately, just the residual effects of it. I get to go last. That's it's like batting last, the home team in baseball. So I get to build off of what these other two speakers have said. And I want to echo some of the things that Magistrate Lindsay-McDaniel and Judge Long said. And I think a general theme that you could hear about what they were saying about our bar here in Knox County is that we have a reputation here of being, in my opinion, a very collegial bar, a bar that generally, we have our times from our spats from time to time, but as a general matter, I think the lawyers in Knox County work well together. They get along, they communicate with one another, and they work towards resolutions of their cases. I have seen or heard of other jurisdictions, I won't name any names or point any fingers, where that's not the case. But I think we have that here in Knoxville. And I think it's very important for our judiciary and for our young lawyers coming in that we realize that and that we work to maintain it. Because once you lose that, that's not something that you can put back in the bottle. I think it's a tradition that we have to, it's our responsibility to work together to make sure that we keep Knoxville as being that kind of bar. And you guys are off to a great start because you're participating in a program like this. Become involved in KBA when they have their socials, when they have their mixers. Go to those things. Meet your fellow lawyers. Meet lawyers who practice in areas that you don't practice in, just so you can talk with them and see, make friendships and develop relationships. Those will become just invaluable to you as you get on in your career. I know the magistrate said, and Judge Long said this as well, something that I regret that new lawyers now are missing out on is that real ability to come hang out in the courtroom and just watch law being practiced. Sometimes being practiced well, sometimes not being practiced well. You can learn how to do things and how not to do things. And I think, unfortunately, some of our new practitioners, they've really been deprived of that opportunity in many ways because of the pandemic. You can still do it to some extent, though. Most of our court in criminal court is video-based. So if you have a case on, handle your case, but feel free to stay on, watch more of the docket, see how these lawyers are handling certain issues. But then certainly once we do get started back, try to be in court as much as possible, to get the appointments like Judge Long mentioned, because that's the easiest way to get them, but also just to see how other lawyers do things and talk with them. talk with those lawyers. If you see a hearing and if you like what a lawyer did, go introduce yourself to that lawyer, pick their brain about it. Lawyers love to tell other people how much they know about things, generally speaking. So you will flatter your more experienced colleagues if you go and ask them that. And it's a great opportunity for you to learn things as well. Part of being a member of a bar that is a collegial one like we have here in Knoxville, and this is something that Judge Long mentioned, we communicate with one another. Okay, so like she said, if you know that a hearing you're not going to be able to proceed to a hearing, call the prosecutor, call opposing counsel, let them know that. Let the judge know, let the judge's secretary know if, as long as opposing counsel is okay with that. So we won't be preparing for the hearing. You know, if I have a bunch of pleadings back here, I'll be reading those in the days leading up to the hearing. Let us know if it's not going to proceed. Get to know, if you're practicing in the defense bar, get to know the prosecutors. Okay, they are opposing counsel. They are not your sworn enemy. And I'm really surprised sometimes when I see attorneys coming into court and opposing counsel haven't spoken about the case at all prior to court. And a lot of times issues pop up where if they just had a phone call or an email beforehand, they really could have avoided some of the issues and resolved some of those issues. So get to know your opposing counsel, get their cell phone numbers, text them on cases, have that type of relationship where you can communicate freely. Now, if you are taking appointments, I think when it comes to criminal court, you know, as Judge Long mentioned, if you get appointed in sessions, you're going to maintain that appointment as the case goes through the grand jury and comes up into criminal court. So if I'm giving you a new appointment for whatever reason in criminal court, it's most likely because either the public defender or the previously appointed private attorney has developed some sort of conflict, or perhaps the client had a retained counsel down in general sessions court, and now they're indigent and cannot afford to hire counsel. But I think most of the new appointments that you would be receiving in criminal court would be on revocation cases, where someone's they've pled guilty, their case is disposed of, they're placed on probation, and there has been a violation of probation warrant filed where the state is seeking to revoke their probation. That is a very large part of our docket in criminal court, unfortunately. But that is the type of case where I would probably be most likely to appoint a new attorney. And on those types of cases, I think, you know, getting back to the communication thing, talk with the prosecutor. If you have an initial appearance coming up on this case, especially if you're a new appointee to the case, you know, you'll have spoken with your client, you'll have communicated with them, but there's a prior history to this case that you don't know anything about other than what your client's telling you and what you can glean from the technical record. So give the DA a call. Say, what's going on with this case? What do I need to know? What are you going to be asking for? Are you looking for revocation here? Are you trying to get this person into treatment? You know, what's the state's end goal? And what can we compromise on? Get to know our probation officers in criminal court. If you sit through any criminal court, you'll realize very quickly that we rely in large part upon the recommendations of the probation officers, either with state probation, with CAP, which is the Community Alternatives to Prison program. It's run out of the sheriff's office here locally. And we also have the Day Reporting Center. We're lucky to have one of those here in Knoxville, which is a subset of state probation. Get to know those probation officers because they are the ones who are working with your clients, who are developing those working relationships with them, and they will be the ones actually submitting the reports into court. And I think the most successful lawyers I see in court are the ones who have that relationship with the POs, where they can call them up and say, here, let's work together to come to some sort of treatment plan for these clients. And when it comes to, you know, probation revocation cases are hard because it's a pretty low threshold for the state to meet in terms of proof, right? The state just needs to prove by preponderance of the evidence that this person has violated some term of probation. Generally, that's not a very heavy burden for the state to carry. So the question quickly becomes, okay, then what? What to do? Don't be the lawyer who comes into court after your client has either submitted to a revocation or has been found guilty of violating his probation and say, well, just give him a second chance. Okay. Work on the case to the extent where you can go a step further and provide me with a better alternative than incarcerating this person. Those are the really effective attorneys that I see on these types of cases, where they can come in and say, look, does my client deserve a second chance? Maybe not, but pragmatically speaking, where we are now, we have this plan in place. I've worked with state probation. I've worked with some of the release coordinators with the sheriff's office. I have this halfway house lined up. I have this inpatient treatment lined up. And pragmatically speaking, this is the best option going forward to returning this person to being a productive member of society. And that really gives me something to chew on as a judge, because then I'm sitting there thinking, okay, yeah, they probably deserve to serve some time, but then you're going to be here in 3 or 4 years in the same boat dealing with someone who has unresolved issues. And here's an opportunity to take care of that now. But that's going to fall on the defense attorney to work up those solutions and make that happen. So that was probation revocation cases. I'll talk a little bit about our trial docket. And I hope that I do get to see some of you guys coming up on your sessions appointments and trying cases up in the criminal court. I'm in Division 2 of the criminal court, so we have 3 criminal court divisions. Here in Knox County, we divide our cases evenly. They basically go 1, 2, 3, 1, 2, 3 as they come out of the grand jury, with the exception of homicides. We set those out separately, and then we divide those up evenly. So none of the 3 of us get overloaded with homicides. But you guys can probably figure and know that our trial schedule, our trial docket is really backlogged at this point due to the pandemic. They were shut down. Jury trials were shut down almost a year ago, about a year and a week ago. We were able to reopen and right after July 4th, and we had some jury trials. I think among the 3 of us, we each had about 4 or 5 jury trials between July and November. They shut down again after Thanksgiving, and we haven't been able to conduct jury trials since then. Now, we are planning on opening up here in April, but as a result, we have a big backlog. We have a bunch of people who are awaiting trial, who either can't make bond or their bond has been revoked because they have picked up new charges while on bond. And we've got to bring those cases to trial. So as a result of that, I'm very jealous of spots on my trial docket. And I'm generally very patient, probably more patient than I would be with giving lawyers an opportunity to set a case for status a few times if they're working towards resolving that case short of trial. As long as I get the feeling or the understanding that they are taking bona fide steps to resolve the case, I'm going to give them that leeway and allow them to try to work towards some sort of agreed resolution on the case. But once a case gets on the trial docket, I think it's very important to understand then that's 2 parties telling me, okay, we cannot resolve this case short of a jury trial. Well, that tells me it's ready to go to trial. It's ready to be heard. So once it goes on the trial docket, that's what I expect to happen. I expect all of the, any pretrial litigation that needs to take place. If you have a motion to suppress, do not come in and file that the week before trial. That is something that needs to be heard months ahead of trial, so we can take a good look at it. I can sit down and put out a written order on it. Don't turn into the type of attorneys who file this stuff at the last second because their case isn't properly prepared for trial. We set numerous cases for trial every week. Unfortunately, we just have so many cases It's not unusual to have more than 5 trials scheduled in 1 week. And obviously you're not going to try all 5 of them, but what often happens is that the person will decide to plead guilty prior to trial, and that will settle the case short of having a trial. What's been very important, and it has been the practice probably for years here in Knox County, is that people would come in the morning of trial and say, hey, we've reached resolution on this case. I know we've called a jury in. I know you got 50 people sitting back there in the back hall ready to come in on jury service, but we've reached a resolution. And what I told the lawyers when we started trying cases again last July was, we simply can no longer do that. With the advanced planning that is required, the logistics of dragging people up here to the courthouse just to get ready for a jury trial under these public health conditions. What I've been telling lawyers, if you want to settle the case, do it the week before trial. But once a jury is called in and once Monday rolls around, it's too late then. If the case is set for trial and we've reached that point, it will be going to trial no matter what. And I think that just gives certainty to everybody and lets them know that we are in fact going to trial. Sometimes people will move to continue a trial, and sometimes these are good motions and sometimes they're not good motions. Sometimes it's just a motion that I haven't done the work that I need to do on this. Never put in a motion though that this is just a first trial setting. Okay, so there is no such thing as just a first trial setting. Like I said, if you ask for a case to be put on the trial docket, that means it's ready to be heard. And I really, I want us to get out of the mindset that we've had for a few years. Is like, well, you set it for trial 1 or 2 times, and then finally, by the time you've set it 3 or 4 times and it's about 4 years old, we'll bring it to trial. I think we can bring cases to trial much more quickly, and that provides certainty. That's a good thing for everybody. That's good for the defendants. That's good for the victims in these cases, and that's what we're trying to do in Division 2 of the criminal court. I don't want to take any more time. I want to make sure that we have enough time for questions, so I'll turn it back over to Marion Campbell.
Thank you, Judge Hixson. So we are going to now go into the question and answer part of the program. If you do have any questions that you think of now, go ahead and DM them to me, but I'm going to start going through the ones that we do have. So Judge Long, there's a question for you. A participant asked if there's any way to find out about holds or outstanding warrants from other jurisdictions before court.
Generally, the clerk, like Adam is my clerk, one, if you approached him on the court date, he could tell you. You could probably, I think Jim's has a screen where you can see that, but I'm not positive. That would be something to ask the clerk about, and they can give you the most direction on that.
All right, thank you, Judge Long. I think the participants do also generally want to hear about any advice you all might have in terms of motion practice. Judge Hixson mentioned not putting "this is just a first trial setting" in a motion. If each of you could maybe speak for a moment about things that you like to see in motion practice from attorneys, or like no-nos, like do not do this in your motion.
Well, when it comes to motion, I think the most important thing is to plead with specificity. You see the appellate courts complaining about that quite a bit, is that they get a motion to suppress, and it's something along the lines of, well, motion to suppress all statements made by the defendant. Like, okay, that's a very broad form of relief that you're asking for there. So you see that a lot on motions to suppress, but I think just in general, with any relief that you're asking the court for, be as specific as possible. If you're talking about statements that are made on a police video, give the time code of the statement that you're seeking to suppress, the specific statement, and the specific constitutional reason why suppression is necessary. Don't leave the judge in the position of reading a motion and saying, I don't know what they want me to do here. I don't really know what they're asking the court to do. Be so specific and list each individual claim. Okay, keep in mind, we operate under two constitutions here in Tennessee. We have the federal constitution and the state constitution. Sometimes the state constitution provides greater protections than the federal constitution does. Don't forget about the state constitution. And if you think you're entitled to relief under both constitutions, list both of them. So if you are unsuccessful, you can preserve that issue for appeal. But I think specificity would be the number one thing.
For Sessions Court, it's not a court of record. So be aware of that. Written motions are rarely used, except mainly by the DA, who's filing written violations of probation. They're filing written notices of motions to revoke or increase bond. But motions that we do hear all the time are bond reduction motions. And even though they're not in writing, there is a kind of, there's a notice requirement to the state that you're going to be bringing that up. So make sure that that's been discussed. A lot of times people are real laid back about it, but you do want to have discussed it with the DA before. If you just throw it out there and it's a domestic assault and they've, got a bad history or whatever, they're going to really object and say, well, they didn't give us the 5 days notice. So that's where that comes up, but nothing's filed. And when I get things that are filed, it kind of cracks me up sometimes because it's like, this isn't really going to do anything. Now, sometimes we will ask you to give us a written argument or some guidance if it's a really particular issue in a hearing. And that's different. That's not a motion. It's just some help. And that may happen, but it's all just verbal, which is nice. And why a lot of people like Sessions Court practice. And that's all I can think about that. Motions.
Okay, so for us, we don't particularly do motions. We do petitions and like petitions for modification. So if you file a petition for modification, you have to file that directly with the clerk's office because that preserves your time limits. So if, for example, you get appointed to a case, you would not be appointed to file a petition for modification, but you might help your client to get that filed. They can go to the clerk's office. If they go to circuit court, for example, Fourth Circuit Court, and they have a pending contempt against them, it doesn't cost them any money to file a petition to modify, but they need to be careful because if they file a petition to modify and it actually, the facts are against them, it could increase their child support as opposed to lower it. So you might want to run the calculation on the Tennessee website on the worksheet to make sure that it would actually result in a lowering of the support as opposed to an increase before you file that. So that would mean reviewing the file perhaps before you actually file it. Sometimes you might want to raise that at the contempt hearing in open court, raise the issue that you're considering a petition for modification, and we'll kind of discuss that in open court and see if that looks like an option. That's something we do routinely. If it looks like other children have emancipated, if additional children have been born, if child care costs have changed, insurance has changed, we'll discuss that to see if that looks like perhaps an option that needs to be explored with them. If you file through the child support office, you don't have to pay a filing fee, but they can take up to 6 months to file a petition on your behalf, and they may decide that they don't think it's a valid petition, so they might not file it at all. That does not save your time limits. And in Tennessee, if you have a child that emancipates, you might have, let's say you have 3 children and the first one ages out, that doesn't automatically change your child support unless you file a petition to modify with the clerk's office. So only when the very last child in between these parties emancipates does it automatically change. So you might have several children that have aged out, but your child support order doesn't change unless you file a petition to modify. So that type of thing, it's important that you get it filed. If you file in Chancery, even if you have a pending contempt case going on, you still have to file, pay the filing fee, which is $75. Even if you do it on a pauper's oath, you still have to pay that filing fee. So in Chancery cases, sometimes people prefer to go ahead and take the extra time to go through and let the child support office review it and make the determination as to whether or not they think it's a valid petition to file. So.
Thank you. So we actually had another question come in, and this is directed to Judge Long. How much credence do you give to procedural issues regarding like a validity of a warrant? And would this be an issue you would rather have addressed on motion, or would you be okay with an attorney bringing it up in court without filing a motion?
Those would be brought up in court without an attorney filing a motion. Like lots of times you'll see citations where when you open it up and look, the officer is not enumerated the elements of the offense. They just say theft, something like that. And yeah, absolutely bring it up and bring it up right then. Bring it up in your negotiations with the DA. And then if that's not fruitful, you've just got to be aware that just because I dismiss a citation or a warrant because the elements are not listed properly, or maybe it wasn't sworn out correctly. For instance, it's a misdemeanor not committed in the officer's presence, and then the officer, aside from domestic assaults, has sworn out the warrant instead of the actual victim in the case, and that gets tossed. All that can, the state can still issue a new warrant, and your client might have lost, their bond on that case, and they just swear out another one. So you got to be sure if your battle is worth fighting or not. You could acknowledge that there's some issues with the warrant, but you've agreed to amend it or whatever. But some things can't be cured that way. So yeah, you would not need to do that in writing. You would bring it to the court's attention right there in court. The first time you see the warrant might be, unfortunately, when you're in court, and you can always bring that up.
Thank you. I believe that's all the DM'd questions that I got. Mary, do you have any additional questions, you think?
Just wondering if there was one best practice that you've seen that really sticks out to you all that we should try to emulate.
For me, I'm sure it's very similar to all the others, is preparation and knowledge. Don't do the good guy defense like Judge Hixson was talking about, and be prepared, know what you're dealing with. I was saying, like Friday, I was in court with a very seasoned attorney, and his client did not show up for a domestic assault charge. The victim was not there. And he was like, I tried to send him a letter, but it was a conflict, and he had probably been on the case literally 5 days. And he said, I tried to send him a letter, and I was like, well, did you call him? And he was like, I don't have his phone number. And I pulled out the affidavit of indigency, and I was like, every single one of these affidavits of indigency have a phone number, an email address, if they have one, a good valid address. They change their addresses all the time. It's like, don't appear lazy, and don't appear and know what you're dealing with. And it's basically talking to the DA, being prepared. And you've got stuff like that shocks me every day. I'm just like, how do you not know that there's an affidavit of indigency with a phone number? Don't wing it.
Yeah,
We can tell.
I would second that. Preparation is huge. There are a lot of forgivable sins for attorneys, but coming in and just not having your act together and not having prepared for the case, that's not good. So be prepared, be diligent in doing that, and just communicate with opposing counsel. You're coming in there young, you're going to be full of zest to go try these cases, but just always remember, you get more bees with honey, and you can go in there and you can be a zealous advocate for your client, but also be very professional and communicative with opposing counsel. And I think long-term, you'll find that's really the most effective way to handle your cases.
And honestly, being prepared is extremely important. Looking at the file, being aware of the law that applies to that specific part of the case that is being before the court, whether it be a modification or if it's contempt, being aware of the specific provisions of the law that apply to what is being tried is important. And I think also knowing your client and understanding that they have many components to them. And we all see the same people. I may be the civil magistrate, but I see a lot of the same people that these judges see as well. So if we're all working together, sometimes we, not on purpose, sometimes we're just all interacting in the same unit trying to help these people to get their life together. And part of that can come out. I mean, if, for example, I may have somebody trying to get a modification of child support and they're in custody, they are angry, they're bitter, they're not paying their child support, they've got drug issues, they've had theft problems, they're missing court because I've got them in on a child support case, they're missing their court over there, they haven't told the probation officer what's going on. So as the attorney, look at what's going on with them. They're not just the one issue perhaps you've been appointed on. Look at the other things that are going on with them. See if there's something that you can do to try and help to coordinate some of the other things that are going on. If you find out that they're in custody and they have a criminal case that's pending that they are supposed to be showing up on, call the other county. If they're in another county and they're missing court, let them know, hey, we have them here in Knox County, so that they're not picking up another warrant. Or call their probation officer and say, hey, they're over here and they didn't actually commit an actual crime. They're in jail on child support. That would be helpful. Or if they have an attorney in a criminal case, I will tell the defendant when they're here, I will say, tell your attorneys to communicate with one another so they can work to try and help you. If you're going to go into rehab, that will help you with your child support as well, to try and get a petition filed and so on. If your earning capacity changes and so on, if you get a job, that's going to help you in all aspects of your life. I mean, they have so many parts to them, and a lot of those parts are dysfunctional, and you're helping one part of them, but realizing that they're one whole person can sometimes help them.
Well, I think we're coming up close on time here. It's about 1. So thank you all for offering your tips and words of wisdom to the new lawyers here. I know a lot of it was very helpful, and I've taken quite a bit of notes. So I hope everyone has found this as informative and helpful as I have. I'd just like to remind everyone to look for an email about upcoming events in April. We're going to try to do an in-person event. And we hope that you guys can attend, and we'll see you there. Also keep watch out for the expo. And Mary, you mentioned there was another event coming up in April.
April 22nd is a KBA social. I think it's at Union.
Jax, what's it called?
It's called like Union something. It's near Sutherland Avenue. They have like an outdoor patio too.
Okay. Well, I'm sure Jonathan and the great guys over there at KBA will send out an email with the exact
Union Place Bar and Grill. Union Place Bar and Grill. We're also gonna put this program up on YouTube, and if everybody, we'll send it out to you in an email. So if you want to revert back to any of this, we'll have that for you as well. But thank you, Campbell and Mary, for doing this for us, and also to Judge Long, Judge Hixson, and Magistrate Lindsay-McDaniel. We're really, really appreciative. So thank you everybody for joining us for sure today.
Thanks again.
Thanks everybody.